Hi, everybody. Thank you for joining me here today. We will wait about 1 minute just to let the last few stragglers get into the room, and then we will get started. All right, I am sure that we'll have some more people joining us as we go, but so that we can get through everything, let's go ahead and get started. Nice to virtually see everybody. My name is Kiki Dilly. I am one of the attorneys and shareholders here at Altitude Community Law, and I run our debt recovery department. So today's topic is near and dear to my heart and definitely where I spend the bulk of my practice. So thanks for joining us today. On your screen, you should primarily be seeing the PowerPoint presentation, and you should also be seeing a small box on the left-hand side of the screen with the presenter. That's me. On the right-hand side of the menu, you'll see a private chat icon, and please use that icon to type in any questions that you have throughout the presentation. I will attempt to answer some questions as we go, time allowing, but also, if we start looking like we're getting short on time because we do have a lot of content to cover, then I may cut off answering additional questions until the end. I also have my email address at the end, so if for some reason I don't get to your question, feel free to email me and I will either answer it myself or get it to the correct person to answer. If you have any audio or video issues during the presentation, please click on the no audio or video button below the PowerPoint on your screen and follow those instructions. One CMCA credit will be automatically generated and emailed to you within 48 hours after the webinar, assuming you attended the entire program. Those credits are also not transferable, they're just for you. As a reminder, this presentation will also be recorded and added to our Altitude YouTube channel within a couple of days in case you have to step out or want to share this with any of your coworkers or boards. And lastly, there will be a survey that will pop up at the end of the webinar. I truly appreciate any feedback you can provide me. Your thoughts and opinions do make a difference for future presentations, so I would appreciate if you could just take a moment at the end and go ahead and fill that out for me. So thank you, everybody, for joining us. We are scheduled for an hour, so we won't be taking any breaks or anything like that, and we will just plow through our information. And please let me know if you have questions. Like I said, I'm happy to try to answer those as we go. So without further ado, we'll start talking about collections in general and extraordinary remedies, including foreclosures and receiverships. And just to get started, I do talk some about the general collections process during this presentation. I know many of you are already familiar with it, and we are going to spend more time on foreclosures and receiverships, but it is important to have a good base understanding of the general collections process to understand how foreclosures and receiverships can play into that process and why they might be best in some certain circumstances. So we will talk a little bit about the basic foreclosure process, or the basic collections process as well. First and foremost, I think it's always very important for managers to have a good idea of what their boards think is a successful collection. That is not always the same answer for every board. Certainly, I have worked with boards that feel badly about anything beyond placing a lien on a property, and they don't feel good about that. I have worked with other boards who would rather, foreclose seemingly on their own grandmother than do anything else. So, and the they run the gamut between that, right? There's certainly a continuum of how aggressive boards are and what successful collections look like to them. Some are more willing to keep spending attorney fees and time and effort to go after someone who maybe has been foreclosed on than another board would be. And certainly we will make, and your attorney, whoever it is, should be making recommendations about, we don't think this is a good option to keep, throwing money at, or we think we've reached the end of the road here, or we don't, and here's why. But ultimately, it is up to the board to decide whether or not that collection has been successful or as successful as it's going to be given the circumstances. So we'll talk a little bit quickly about some pre-collection considerations and some techniques that can go a long way to getting people paid before you ever have to get an attorney involved. And then we will also talk about what today's collection process looks like. We'll cover that pretty quickly, like I said, because I do want to focus on foreclosures and receiverships, but it is important to understand the basics of that process so that we understand how foreclosures and receiverships fit into that. All right, so some pre-collection considerations that I'm sure that you are all aware of, but sometimes it is helpful for your boards to remember these things when they're having these collections discussions. First and foremost, your homeowners association is a business, and it is a weird business because it is run by volunteers who generally have no expertise in the area of the HOA business that they are running, but it is a business. And it's also a weird business because sometimes they are in the position to be making judgments and decisions against their neighbors, which is very different than normal business life, where you are doing more of a arm's length transaction with people that you may or may not ever see again in your life. It is definitely weird to ask volunteer board members to make a decision to foreclose on their neighbor that they might see at the mailbox periodically, or at the block party, or what have you. So it is definitely a weird business. It is a more personal business than most businesses, but it ultimately is a business, and the board has a fiduciary duty to make sure that the business, the association, is properly funded. And sometimes that means sending people to collections. Sometimes that means doing more extraordinary remedies like foreclosures and receiverships. So it is important to just keep that perspective that ultimately we are talking about a business. We want to make sure that any association that you're dealing with or that is looking to take any kind of collection action is in compliance with the new laws that just went into effect in August that we've referred to there. It's the HB 24/2233, and then also 1377. Those are the two major laws that went into effect this August that affect what we're talking about today, although certainly there are a whole slew of others that went into effect in August as well that you can learn about in other webinars that we have on our website when we talk about legislative updates. But today we're just focused on the ones that impact collections, foreclosures, and receiverships. We want to make sure that they have their updated policies in place and that they are also following those policies. It doesn't do any good to have the policy in place if you're not actually following the policy and following the policy consistently, homeowner to homeowner, to make sure that you are being consistent with that. You want to know why someone isn't paying. Sometimes people aren't paying because they feel that something that the association is responsible for is not being handled appropriately. In those situations, a lot of time, a little bit of communication can go a long way to solving that problem, and you don't have to ever get an attorney involved for collections at all. A lot of times we find that people just kind of feel like they want to be heard. They want to know why, the ice outside their house seems to never be taken care of, or whatever their situation is. in those situations, it's an easy fix, relatively speaking, to encourage them to come to a board meeting, discuss with the board what their, air their grievances at the board, and tell them why they think that the board is not holding up their responsibilities. A lot of times, once they can have that discussion with the board, if they are willing to come to the table and actually discuss with them, a lot of times they are willing to then see the bigger picture, understand the bigger picture, and go ahead and pay. Sometimes not, but it's worth a try. And then finally, help us help you. And what I mean by that is anytime you or the board has any information about anyone that is going into collections, please please forward that information to us. Anything from like, here's a copy of a check that they used to pay assessments last year. That gives us banking information that we can use. If a board member knows that they park a work truck in their driveway, or they see them driving it, into their garage every day, that'll provide us employment information. Anything like that can be really helpful. License plates, car types can help a process server if they're trying to get them served. Any of that sort of information that you may or may not have, more often your boards will have that information, and they don't always realize that that is helpful information to us. It is helpful to send that to us and allow us to be as efficient as we can. So updated collection policies needed to be in place in August of this past year, or this current year, August 2024. If you have any associations that do not yet have their updated policy not only drafted, but also signed by the board, you want to make sure that you want to get that in place as quickly as you can. Even if you have associations that maybe don't currently have any delinquencies, it's always best to have these policies in place before you get a problem, rather than going backwards and trying to get all of the steps into place to then deal with a problem once it's happened. Again, what we're looking for here is efficiency and putting our associations in the best possible position that we can to help them out. So, some collection policy requirements. A lot of these are required to be in your collection policy, although not new. They are requirements. Your collection policy must state when assessments are due and when they're delinquent. And just as a side note, I do see a lot of collection policies that say, for example, assessments are due on the 1st of the month, but then they don't actually say when assessments become delinquent. You want to make sure that that's in there too. Usually it'll be language like assessments are due on the first day of every quarter and are considered delinquent if not received by the 10th of 10 days later, or they're due on the 1st of the month and they're considered delinquent if they're not paid within 1 day of that, or by the next day, or something along those lines. You do want to have that explicitly stated in there when they become delinquent. Your collection policy needs to say the amount of the late fees, and I mean the dollar amount of the late fees, not just that late fees will accrue at the board's discretion or for a reasonable amount. You do want to have the dollar amount of the late fees listed in there, partially because you want to make sure that everybody is being handled the same way and that one person isn't getting a $10 late fee and then a year later somebody else is getting a $25 late fee. You definitely want the consistency, but just for the sake of making sure that the next board understands what the prior board was doing and that everyone has proper notice of what charges they can expect if they fall delinquent. You want to have the interest that can be charged. That is capped at 8%, regardless of what the governing documents of the association say. Interest cannot be higher than 8%. And return check fees need to be stated in there, which is also limited to $20 for the return check fee. You want to have listed in your policy the circumstances and the terms of when payment plans are permitted, and that any payment plan will be at least 18 months or will be offered to be at least 18 months. You have to say how payments will be applied. That is a change from 2022. That previously payments could be applied however the board decided. But in 2022, there was a change saying that assessments had to be applied first to unpaid assessments and then late fees and attorney fees and everything else after that. So to make sure that that change got updated into the collection policy accurately. And there also is a requirement that notices be sent to owners and to any third party that they request, and that owners are also allowed to make a language request on what notices they receive. And the association is then required to have those notices sent to them in the language that they prefer. All right, delinquency notices that go to the homeowner. A lot of associations give one or more courtesy notices, and the law doesn't require those. We generally recommend sending one or two of them before you start getting into the meat of what the statute requires, because the required notice gets expensive quickly. And so we generally recommend that you send out one or two courtesy notices according to your collection policy. Again, you want to make sure that your collection policy actually reflects the practice that is being done. If it says courtesy notices should be sent, then courtesy notices should be sent. If it doesn't, then let's update that policy to reflect the practice that's actually happening. But the law does state what has to be included in one notice, and we generally refer to this as the payment plan offer letter or the required delinquency notice, anything along those lines. This one notice has to have the total due and an accounting of it, which is usually a ledger that's attached to it that goes back to the last time the balance was paid in full. So it itemizes every charge since then. It says whether the balance is comprised of assessments, violation fines, or both. Usually we see that as a little checkbox that one says that this balance is comprised of assessments, one says unpaid violation fines, and then another one says both, and you just check the appropriate one. It has to provide the homeowner 30 days to cure or to enter into the offered payment plan. It has to provide the name and contact information of the person, and I mean person, not the title or the main number for your office or the main support email for your office. It needs to list the name of a human that the owner can contact to verify the debt or enter into a payment plan. That is something that we frequently see is incorrect on payment plan offer letters. And unfortunately, if we see that sort of an error, we generally are going to send it back to your office and say, hey, there's a lot of risk involved in moving forward with this collection as it is because we didn't strictly comply with the statute. So we really recommend going back, correcting this issue, sending it out again, and then starting at that point. The risks of proceeding and not having all of your ducks in a row can get very expensive quickly. So that's why we recommend that we make sure that everything is complied with to the letter. Your offer of payment plan is going to be for 18 months with two options. One of them is going to be the total balance due divided by 18 plus the current monthly or quarterly assessments when those are due. That one's easy. The other one is 17 monthly payments of $25 a month plus current assessments when due, and then a balloon payment in month 18 with the remaining balance due. The reason that we recommend offering both of those is because the statute is not terribly well written. And in one section, it says that the association has to offer an 18-month payment plan with equal payments. In another section, it says if the association is going to foreclose on an owner, which is part of what we're talking about today, that they have to offer the $25 minimum payment plan option. And so a lot of times you'll see as we get further into this, we don't know going into a matter whether the regular collection process is going to make more sense or get money faster, or if it's going to make more sense going the foreclosure route. And so we say at the beginning, just cover both of your bases right from the start, offer both payment plans, and you're covered either way. We have to have delinquency cure language. We also have to have covenant enforcement cure language, even if your balance is only made up of assessments. Recognize that doesn't make any sense, but the statute doesn't say it doesn't have to be there if you only owe assessments. And then there also has to be language about whether or not, or language that small claims is an option for the homeowner and for the association if they so choose. I would suggest if your payment plan offer letter has not been either drafted by or reviewed by an attorney, it is well worth the money to have an attorney look at it and just give it their blessing, or make some changes based on what the statute requires, because you certainly want to catch those errors early on rather than find out later when it becomes an expensive problem. So your payment plan offer letter, this is a change that came in August, has to be sent by certified mail and by 2 of the 3 following methods: email, phone, or text. There is no longer any posting requirement. There is no longer any regular mail requirement. You have to do certified mail to the mailing address, and then you do email, phone, text, 3 of those. So then the first question that we always get is, what if we don't have a phone number for them? Unfortunately, the statute says that you have to send it by email or phone or text to a phone number or an email that the homeowner has provided the association to use for association business. If you don't have one, you cannot strictly comply with the statute. We have a couple of workarounds to try to get you in compliance as well as we can, but recognize, your boards need to recognize that there is a risk right now, as the statute is written right now, by trying to collect against someone who has not provided that information to you. So if you find yourself in that situation, please reach out to me, reach out to your collections attorney, and find out what they recommend doing and how they recommend handling that situation moving forward. We can certainly try to find contact information for them. We can, do a skip trace on people. Obviously, there's Google. The problem with that is that, yeah, you might reach them and everything might be fine. They might pay, or the judge might say, you didn't get that number based on, it's not a number that they provided you for association business, so you haven't complied. That is going to be a very county by county discussion and analysis that needs to happen based on what we and other attorneys know about how different counties are looking at things. So please reach out to your collections attorney if you do have that question. I also am constantly being asked, do we have to read them the entire letter when they're on the phone? My answer is, I think you should. Because again, in order to strictly comply with the statute, it says that this letter has to get to them by phone. How else do you get it to them by phone other than reading it to them? Certainly if they say, stop reading this letter to me, then you make a note of that and you stop. But I think in order to put the association in the best possible position, you need to read them the entire letter by phone. Same question with, can I attach the letter as a PDF or a picture to the text? I think that's probably fine. And I think that's probably the smart, safest way to get that letter to someone by text. I don't think that you are strictly complying with the statute if you send someone a text that says, hey, this is Joe Schmo from your management company. We have important information for you. Please call me, or please log on to the homeowner portal. That does not strictly comply with the statute. Again, how judges are going to take that will probably differ judge to judge. So if you have questions, then reach out to your collection attorney about the specific association, and we can talk about what our experience is with that particular judge. But best practice is certainly get that payment plan offer letter to people fully, the full payment plan letter in all of these ways. All right, in order to refer a delinquent account to collections, the board in executive session needs to vote on sending that particular owner to collections. That is not something that can be delegated to the manager anymore. That has to be done in an executive session by the board. And you want to document that with either a signed resolution or meeting minutes saying that this is what happened. Certainly, if you are putting it in meeting minutes, you do not want to say John Smith at 123 Main Street got voted into collections. We recommend you using account numbers to identify people that were sent to collections. All right, and so when we get into the meat of how collections work and what is going to be a better option for foreclosure or receivership, we're starting to look at things like, who is the debtor? Is it an individual? Is it a human homeowner? Is the owner a business or an estate or a trust? Is the owner in state, out of state? Do they live in the property or do they not? What is the state of the property? Is it in ruins? Is it pretty well kept up? There's a lot of different things that we look at in this category to try to put the association in the best possible path to be able to collect and put them on the right path of, let's do personal collections, let's do a foreclosure, let's do a receivership, let's do some combination of those things. So we're always looking at the specifics of the situation, and it gets us back to what we talked about before of help us have all the relevant information to be able to make the most efficient suggestions and recommendations as possible. So when we're looking at collections, we're looking at two possible routes to collect. We can go after the individual owner's property. It's generally going to be through a collections lawsuit where we're looking to collect against the owner by the owner's assets. So we're looking at things like wage garnishment, bank garnishments, things like that. Or are we going to try to collect against the lien on the property, and we're really going after the property? And if we're going after the property, then we're going to be looking at a foreclosure. Obviously, your likelihood of recovery depends on a lot of factors. Lower balances are easier to collect. Faster turnover is easier to collect because usually if you have someone in collections with their HOA, they're not just in collections with us, they're also in collections with, you know, their cell phone and their cable bill and everybody else. So the faster you can get someone into collections, the more likely you are to get paid. Public trustee foreclosures can certainly throw a monkey wrench into things, as can bankruptcies. But for our purposes in this class, we are assuming that we don't have public trustee foreclosures, which is your mortgage company foreclosing, or a bankruptcy pending. So when someone comes to us for collections, regardless of what we're doing, our first step is to send out a federally required demand letter to the owner. This is separate from the payment plan offer letter and is something that is required under federal law because we're considered debt collectors. So after the payment plan offer has gone out, your 30 days have passed, you haven't heard anything, or they agreed to a payment plan and they defaulted at least 3 times, 15 days late, then you can send them to collections. We have to send out our initial demand letter. Then at that point, we can look at, does it make sense to go after the individual owner for their assets, or does it make sense to go after the property and foreclose? That demand letter provides the owner 30 days to dispute the balance. It's actually 30 days from the date of receipt, and those are not sent certified mail. And so we calendar it for 35 to 40 days, depending on weekends and holidays and things like that in there. We have to give them the 30 days to get back to us to tell us why they feel that they don't owe the balance, or to pay it, agree to a payment plan, things like that. So generally what we're looking at first and foremost is the regular collections process, and that's suing the owner individually for the balance. That's generally what that process looks like. You all have the PowerPoint, so you can look at it on your time if you like, but suffice it to say, there's a lot of moving parts here and a lot of different ways to get you where you want to be. The goal of that whole process generally is to get judgment against a person. Obviously, if they pop up and they say, I want a payment plan, I want to pay in full, we're happy to do that. But usually if somebody is ignoring your letters and then they're ignoring my letter from an attorney's office, more times than not, a lot more times than not, they are also going to ignore the lawsuit that is served on them. And the goal of that lawsuit is to get judgment against them. That is when the court decides this is the balance that is due to the association as of this date. And that getting judgment is when our collection options switch from trying to get voluntary payments from the owner to now we can get involuntary payments from the owner through things like garnishments. All right, generally we're looking at 2 different types of garnishments when we are trying to collect against someone once we have judgment against them. The more favorable, the easier garnishment is the wage garnishment, which is called a writ of continuing garnishment. This is a very simple process from our side. We find out where they work. We file documents with the court asking for the garnishment. The court authorizes it. We send the garnishment for service on the employer, which is way easier to serve than the homeowner because it's usually a business and they're not trying to avoid service at all. And then it is the employer's responsibility to start withholding up to 25% of the homeowner's income. And that garnishment stays in place for 6 months or until the judgment is paid. And as long as that garnishment is out there, the employer keeps sending a check every 2 weeks or every month or however often the person gets paid. That is the most painless garnishment on our end to get money coming in consistently. There are a few things that can happen that can throw off a garnishment. Sometimes, obviously, people get fired, they lose their jobs, they get laid off, they choose to leave their job for whatever reason, or we can't find good employment information with them, or maybe they are not employed. Also, we can get kicked out of line of our garnishment for higher priority garnishments like taxes or alimony, child support, things like that. But most of the time, if we get a wage garnishment in place, it's pretty successful for a while. Like I said, it stays in place until the judgment is paid or until 6 months is up, but that just allows other creditors to come in and try to get their garnishments in place. Once that 6 months is up, if there's still balance due on the judgment, we just file a new garnishment and get it in place again right away. The other kind of garnishment that we're generally looking at is a bank garnishment or bank levy. This one is less popular, less effective sometimes, because we don't have any way of confirming how much money is in a bank account before we do the garnishment. So sometimes we'll try a garnishment and they will have closed their account, or the garnishment comes back and says, you got $6.12. What would you like to do with this money? Other times it comes back and it says you have $5,000. It is very unpredictable. When it hits, it's great. When it's not, when it is just unpredictable and not as easy of a way to get consistent money for the association. The way that the bank garnishment works, it starts out like the wage garnishment in that once we have judgment, we file it with the court. The court authorizes the bank garnishment. We send it for service on the bank. Again, the bank is not trying to avoid service in any way. They accept the garnishment. They put a hold on all accounts that has that homeowner's name on it up to the amount of the judgment. And then they let us know how much money is being held. Sometimes there is money that is not garnishable, that is exempt. So money from things like disability payments, the alimony, child support, things like that, that is not garnishable money. And sometimes the bank will come back and tell us that we can't have the money because it is from those exempt funds. Other times the homeowner tells us. But the other downside to the bank garn, in addition to the unpredictability of how much money is out there, is the fact that once the bank tells us how much money is being held, we then have to serve the owner with bank garnishment documents, which provides them an opportunity to tell the court why we shouldn't be allowed to have this money. But it is often difficult to get someone served with that bank garnishment because they've already been served with the lawsuit and now they're being served again. And a lot of times it's the same person that is there to try to serve them, and they've gotten a little more savvy to the process and they just don't open the door to the process server. So there are several reasons why the bank garnishment is less predictable than a wage garnishment, but it is a great option in the right circumstances. So sometimes we'll have judgment against a person and they fall under one of these special collection problem categories and we're just not able to get them served. Sometimes they are self-employed, which means doing a wage garnishment against them is probably not a great use of funds. Even if we garnish them, we're going to then be having an argument with them at the courthouse over whether they make any money, because they claim they don't get paid anything and they're the company, and so they're not particularly motivated to garnish themselves when they're self-employed. And while that is not a valid legal defense to the garnishment, it often leads to multiple court appearances where the court is requesting more and more and different information from them to prove whether or not they make any money, and it just becomes not cost effective at that point, when we have other options that may work better, more efficiently. Military individuals are more difficult to collect from through the regular collections process. Bank-owned properties that have been foreclosed on by the mortgage company, it is not a good use of funds, or it's certainly inefficient to try to sue a bank and then garnish a bank to get paid. In those situations, it makes more sense to just go after the property rather than the bank owner. Same thing with properties that are owned by LLCs, trusts, estates of deceased homeowners. A lot of times the property is the biggest asset that those owners, company owners have. So rather than trying to find the right person to serve to sue a trust, or then get judgment and try to find what bank the trust uses, a lot of times that is not very efficient. And in those cases, sometimes we will look at foreclosure. Also, sometimes you have people that own properties that are humans, and usually we can do a pretty decent job of collecting against humans, but sometimes we run across people that are what we refer to as judgment proof, which means we can get judgment against them, but they just don't have any assets to collect from. Sometimes these are because they are people who are unemployed or underemployed, and don't make enough money to garnish them. Sometimes they don't trust banks and they don't keep their money in a bank. Sometimes they are younger kids who mom and dad pays all their bills. They're students, and that's why their parents pay their bills, and they don't have any income of their own coming in. So there are certainly some circumstances where people cannot be garnished effectively, and in those cases, that is when we start looking at what we have called extraordinary remedies, foreclosure and receiverships. So when we're talking about judicial foreclosure, which is what the association is doing when they foreclose on a property, it's important to talk about what we're not talking about. We're not talking about public trustee foreclosure, which is the process that the mortgage company gets to go through in Colorado to foreclose on a property where the owner has not been paying the mortgage payment. We're not talking about a deed in lieu of foreclosure, which is something that happened a whole lot more back a decade ago or so when the economy was not very good, and people were finding themselves upside down on their properties, owing more to their mortgage company than what their property was worth. And so in those situations, sometimes the mortgage company would offer for the homeowner to just sign the property back over to the bank mortgage company, rather than going through the full foreclosure process, incurring the attorney fees and the time and the expense and the headache of all of that. If the owner wasn't going to fight the process at all and was willing to just leave the property, sometimes they would do a deed in lieu of foreclosure where the owner would just sign the property back to the mortgage company. We're also not talking about a short sale where, again, the property is upside down and with all the liens against the property, the owner owes more than what is due than what the property is worth. Sometimes mortgage companies and HOAs and every other lien holder, second mortgages and other people were asking to reduce their balances or accept a lower balance in order to allow a sale to go through. But none of that is what we're talking about. What we are talking about is a judicial foreclosure where the association goes to court and asks the judge for permission to sell the home in a foreclosure auction to satisfy the association's lien for unpaid assessments. So this is where we are going after the lien against the property, not the assets of the individual owner. It's all about the property and the lien. Now, practically speaking, I'm sure the homeowner feels like this is about them personally because it is their home. But from a legal standpoint, this is about the lien on the property. So when do you want to consider foreclosure? Sometimes we have chronically delinquent people who are on what we refer to as the collections treadmill, where they come into collections, they get paid through the regular collections process, and then 6 months later, they're right back in it because they haven't kept up with their current assessments in the meantime, or they just are not getting the message that they need to pay their HOA. Sometimes with those people, if you foreclose against them, foreclosure is more expensive. And so if they want to stop the foreclosure, it hits them in the pocketbook and they get the message that they do in fact need to prioritize paying their HOA. For the judgment-proof people that we were talking about, if you have someone who doesn't have any garnishable income, doesn't have any garnishable money in their bank, or we're not able to find that information from them for whatever reason, and sometimes the judgment or foreclosure against those people is frankly the only collection option to try to get paid. If you have a large account balance, and by large I mean over $20,000 or so, it probably makes sense to try to foreclose against someone rather than take the collections route, because although we can certainly get judgment against them and try to collect through a garnishment, unless you have somebody who is getting paid an awful lot of money, it's going to take a long time to collect $20,000 wage garnishment. Sometimes people do make a lot of money and we do get really big garnishment payments, but sometimes not. If you have those large balances, sometimes it will be more efficient to go the foreclosure route. If you have an owner who we can't find or can't be served, whether it's because they live outside of the country most of the time, or they're really good at avoiding service, foreclosure can be a good option on those people, because in the collections process, the process server has to hand the papers to the owner, or there's a limited number of other people they can serve, a member of their family over 18 at their house, things like that. And so if people are good at avoiding service, then it's pretty easy sometimes to avoid the process server. And then we're never able to get that judgment against them. There are other options in the foreclosure realm because we're going after, again, the lien on the property, not the assets of the human. And so the court, once we can show them we legitimately tried really hard to serve the owner of the property, we can then ask the court to allow us to serve them by publication, which just means that we run an ad in the newspaper for a number of weeks, and that counts as valid service. So that is kind of a workaround for those people who we are not able to serve for whatever reason. And then you always want to make sure that there's equity in the property, because one of the reasons to foreclose on an owner generally is to try to get paid. It's usually not because we're trying to actually own the property or take over ownership of the property. We are usually wanting to try to get money. And so we want to have equity in the property to either encourage the owner to come up with the money to pay the balance and keep their equity in the property, or alternatively, if the owner is not going to come up with the money to keep the property, then we want the property to have equity in order to be attractive to an investor to come in and pay the association what they're due, and have the investor take over ownership of the property. Because either way, we are getting the association paid. But you need to have the equity there to entice people to want to pay it. So what are the benefits of a foreclosure? There's a high rate of recovery of the full balance owed because it is an extraordinary remedy, right? People don't want to lose their homes, and they will come up with the money more times than not to stop the foreclosure. It also stops those habitual delinquencies because it helps people to understand that they need to pay their assessments or their association is going to foreclose on them. And it certainly will get out in the association that the board is serious about delinquencies because they're foreclosing on people. We don't shout it from the rooftops that an association is foreclosing on someone, but the information certainly gets out into the community. And sometimes you do have those owners where they are just perpetually in collections. They are not able to pay their bills. And sometimes it is best for the community to not have that person be an owner in the association anymore. And in the right circumstances, and certainly speak with your foreclosure attorney about the individual circumstances. But if you have people that are not able to pay, it is an unfortunate reality that sometimes it is best for the association as a whole to force transfer of the ownership and get that person out of the community and have someone else take ownership of the property that will pay the assessments moving forward. Now, there are some new requirements with foreclosures as of August when the new laws took effect. We do have to have personal judgment or to have attempted to serve an owner for 6 months before we just move them directly into a foreclosure. There are some exceptions to that, like if the homeowner is deceased, obviously we can't serve them. If they have filed bankruptcy in there, and that's why we couldn't serve them with a lawsuit. If it's not the owner's primary residence, they lose that protection of the legislature trying to keep people in their homes. And if the homeowner is not a human, so if you have LLC, trust, estate-owned property, bank-owned property, things like that, we don't have to get personal judgment against them first. And when I say personal judgment, I mean serve them with the regular collections lawsuit that we would usually be trying to garnish them to try to get paid. We also have to offer mediation to owners 30 days before filing the lawsuit. And we have to notify other lien holders 30 days before filing the lawsuit. That notifying the other lien holders is actually a benefit to the association, because if we are notifying second mortgages that their lien is about to get wiped out, sometimes those second mortgages do pop up and pay off the balance that the owner owes, and then add it to the second mortgage balance in order to not get wiped out. So foreclosures take a long time. There's no getting around that. Uncontested, they can take a year or longer. Contested, they can take a year and a half or longer. Things can get expensive, and there are new attorney fee limits on what can be collected through a foreclosure. However, the legislature also gave us some caveats to get around those attorney fee limits, and they're very limited to if you have an owner who has the financial ability and economic, physical ability, there's several things, to pay the association and just decided not to, then we can get around those attorney fee limits. Although this is a brand new law, and so I fully expect that different judges will find that line at different places. So again, I would recommend having a discussion with the association's foreclosure attorney about, each individual property and what our best guess and recommendations and professional advice is given that particular situation. So if you go all the way through the foreclosure process and the association becomes the owner of the property, which frankly is pretty rare, because of all of those safeguards that we're looking at on the front end, we want there to be enough equity in the property that someone pays the association and you don't end up owning the property. But even if you do, it's still not the end of the world. The association can sell the property, they can refinance it and keep it if they want. I've had that happen a couple of different times. Once because an association actually wanted to own a property in order to provide the on-site maintenance person with a place to live. And the other time they wanted to keep a property to have a unit available for owners to rent for their guests coming in from out of town. So sometimes it happens, it's pretty rare. The other thing that the association can do, they can rent out the property to a renter until the mortgage company eventually comes in and forecloses on it, and at least they have recouped if not all, a vast majority of the money that they spent on the foreclosure. So it's pretty unlikely that the association becomes the owner, but it's not the end of the world, certainly, even if they do. If your first mortgage comes in and starts a foreclosure while the association is foreclosing, then that foreclosure would wipe out the association's lien. And the association has some options, but what to do in that circumstance really depends on a case-by-case analysis of where you are in the process when the first mortgage starts theirs. And so again, that is a case-by-case discussion with the attorney. But a lot of the time, you still end up with some options in order to get some money for the association, even in that circumstance. Because again, on the front end, we try to do a lot of research into it and confirm whether or not we think it's likely for the first mortgage to be starting their own foreclosure anytime soon. So the other thing that we're talking about is receiverships. And a receivership is when we ask the court to appoint a third party to come in and act as a landlord on the property. This is completely separate from either a foreclosure or a collections lawsuit, although the receivership can happen during either of those processes. So you could do a receivership as part of your collections lawsuit against the individual owner. You can also do a receivership in tandem with your foreclosure to try to get some money out of the property while the foreclosure is going on for that year, year and a half, however long it takes. So there is an independent third party that we ask the court to appoint as landlord on the property. It can't be me, it can't be you, it can't be a board member, it can't be another homeowner in the association. It has to be someone who is an independent person. And there are people who have businesses that their whole job is being receivers. So the receiver, the court authorizes the receiver, the receivership. The receiver then contacts the tenant, if there is one, and the homeowner and says, hey, I've been appointed by the court to take over this property, essentially. And moving forward, tenant has to pay their rent payments to me until the association is paid. So we are basically intercepting those rent payments from going from the tenant to the owner. We're taking those payments for the association. If there is no tenant, then the receiver gets into the property, they get the locks changed, they clean it up, they get it rentable, and they find a renter to go into the property for however many number of months that it takes to get the association repaid. Then the receivership stops. When they go into the property, if the property is vacant, they don't have to, make the property a great place to live. They're not upgrading countertops and bathrooms. They're just making it livable, right? They're making sure the water is on. They're making sure that the power is on and that the refrigerator works. They're getting all of those utilities put into their name, to the receiver's company's name, making sure that it is a livable place, but they're not upgrading the landscaping while they're there. They will, however, fix covenant violations while they're there. They can do that sort of work, but they're not going to, tear out a rock bed and put in a koi pond instead. So the receiver is reaching out to the tenant, finding a tenant if there isn't a tenant currently there, and they're also reaching out to the homeowner. Usually at that point, a lot of times the homeowner says, I don't want to lose my rent payments because then it's going to cause me to not be able to pay my mortgage payments, and then I'm going to lose my rental property. So a lot of times at that point, the homeowner will pop up and realize that the association is serious and get on some sort of a payment plan to pay the balance. If they don't, then the receiver collects the monthly rent payments from the tenant that either was there already or that they have put into the property. The receiver is repaid for his time that he has put into the property, and then any additional money is paid to the association until the balance due to the association is paid in full, including any current assessments that have come due during the time that the receivership is in place. The receivership is then finished whenever the association is paid or the property is no longer owned by that individual anymore. If it goes on for too long, obviously it can get sold in a foreclosure, but we try to weed those ones out on the front end and only recommend receiverships on ones that are kind of in the sweet spot of a large enough balance to make it worthwhile to do the receivership, but not so long that it's going to go on for 2 years and send the property into foreclosure and then have the owner lose the property, and then there's no more receivership that can keep going on. So when you're looking at a receivership, some factors to look at is if the property is already in foreclosure by the first mortgage, you do not want to be anywhere near a receivership on that. You will absolutely put more money into it than you will have time to get back out. You want to look at the condition of the property. Sometimes that's easier to look at than others. We are not able to gain access to the property until after the receivership has been ordered. So sometimes that's a little bit unpredictable, but sometimes, especially with single family homes, you can gain a lot of insight into how the inside of the property looks based on what the outside of the property looks. So you can have at least an idea of what you're getting into. Also, what is the average rent for the community? Because if average rent is $1,000, that's going to take a lot longer to get the association paid versus if the average rent is $2,500, that might make more sense on a given balance depending on how long it's going to take to get repaid. Another factor to consider is that receiverships are only an option when the property is not owner occupied. We cannot kick an owner out of their home in favor of a receivership. So if the owner lives there, receivership is off the table. And then I included a couple of slides in here about bankruptcy just because they are in fact on the rise a little bit right now. So we have a really quick overview of bankruptcies because those pop up out of nowhere sometimes. There's no requirement that an owner notify us or give us a heads up that they are going to file bankruptcy. They just have to let us know once it has happened. Chapter 7s are the lesser of the common bankruptcies right now. These are generally more when people are unemployed or severely underemployed and they are complete liquidation of the owner's property. They're generally very quick, relatively speaking, about 4 to 9 months. And the association cannot attempt any collections while the bankruptcy is going on. Although once the bankruptcy is over, the homeowner's personal obligation for any balance that was due as of the date they filed bankruptcy is gone. We can't sue them for that pre-bankruptcy balance, but they are still personally responsible for any assessments that came due from the date that they filed bankruptcy moving forward. And also your lien on the property remains valid for the full balance due, pre-bankruptcy, post-bankruptcy, everything. So in that case, if you have someone who goes through a Chapter 7 bankruptcy, they keep their property, a foreclosure can be a great option because in order to stop the foreclosure, the owner would have to pay the pre-bankruptcy balance and the post-bankruptcy balance, even though they are not personally responsible for that debt. That is something that can be really valuable in the right circumstance. So if you feel that you might have that situation, please reach out to your collection attorney and we can take a quick look at it and let you know if that is something that would be a good option on there. Although frankly, your collection attorney should also be bringing that to you rather than you having to look at it the other way. The more common bankruptcy right now is a Chapter 13 bankruptcy, which is known as a reorganization. And this is done by people who have a job and they have enough money to repay their debts. They just need people, all of their creditors, to take a break so that they can have time to pay everyone back. A Chapter 13 is a very long bankruptcy. They usually last, I say 3 to 5 years, but I think in practice they end up lasting a little bit longer than that. But as long as your owner is keeping the property through their bankruptcy, you will eventually get repaid as long as we know about the bankruptcy right at the beginning and can file all of the required documents and get the association covered in the bankruptcy. It is slow and it takes a long time, but you will eventually get paid. Just like a Chapter 7, there's the automatic stay, although in a Chapter 13, it extends to co-debtors, even if they're not also listed on the bankruptcy. As I said with the Chapter 7, the lien remains on the property as well. So a Chapter 13 bankruptcy, as long as your owner is keeping their property, is annoying, but financially not the worst situation for the association. And that one covers that as well. The other benefit to a Chapter 13, if they're keeping the property, is that the owner has to keep their current assessments paid during the bankruptcy, and we have a good threat to them to have their bankruptcy dismissed if they fail to do so. But again, all of this is contingent upon the association jumping into the bankruptcy right at the beginning. So if you get any kind of bankruptcy notifications, be sure to get the collection attorney notified right away so that we can meet these quick deadlines in the Chapter 13 and get the association covered. If the owner surrenders the property in a Chapter 13, it is not a good situation for the association, and you are probably likely to be out of money on that. Although, unless you're dealing with a investment property, most of the time owners want to keep their property through their 13s, and so this is the less common situation. So that is our presentation today. I recognize that I flew through a lot of information, but I wanted you to have the right background to understand the benefits and the drawbacks of when a foreclosure or receivership is the right option. So if you have any questions, feel free to reach out to me there. I do see that there are several questions in the chat, although I think a lot of these came in early on, and I think I answered most of these during later parts of the presentation. So if you have any questions, feel free to reach out to me by email. That's my email address right there. And I will let you all go since we are at time. So I hope everybody has a great rest of their day, and thanks for joining me. Bye-bye.